Looks like Sergeant Bukwacki isn't the only MSP officer who's making headlines this week, as Brian Walsh's attorneys are now requesting all of the data from Trooper Michael Proctor's cell phone. They want correspondence between the Department of Justice and the Norfolk County DA's office, Mr. Michael Meatball Morrissey, in regards to the death of Officer John O'Keefe. Records regarding Proctor's performance, correspondence between federal and local authorities regarding the Sandra Birchmore investigation, among many more. Oh boy, are things about to get spicy. Hello, and welcome to Alexasrewm, where we are not lawyers, we are not medical professionals, we are not law enforcement, we are just people. People who lost power last night in their building and was not able to get part 2 of Duckygate because, as you've been following probably from some of your other favorite creators, Duckygate does in fact continue. So I will be getting part 2 of that, I guess the Duckygate series, up and at 'em and posted for y'all sometime later this week. So just keep your eye out for that. And what a better time to subscribe and hit that notification bell so you don't miss the next Duckygate video from me. But that being said, we are just people who have opinions about all things going on in the true crime community, including this hearing today with Brian Walshe in regards to our favorite trooper pooper, Michael Proctor.
Thank you.
All right, so Mr. Tipton, I've read your motion, an affidavit, a memorandum, I've read the Commonwealth's response. Have you had a chance to look at any of the materials that it seems like maybe the Commonwealth gave you in the last week from when the motion was filed, or?
No.
Okay.
Because frankly,
No. And why is that?
we just got it.
Okay.
Oh, the Commonwealth giving a very delayed response? Apparently, the Commonwealth only responded to this motion, which was filed on September 24th, today, as in Wednesday, October 2nd. So that's a week ago. This was only hours before this hearing was supposed to take place. And surprise, surprise, folks, they objected to many of those requests.
All right, what are we doing today?
Well, I don't want to speak for the Commonwealth, and I want to make sure that Mr. Walsh understands, because I just told him something different in lockup.
Okay.
I think based on the representations of the Commonwealth, both in its communications yesterday and then this today, there's a lot of discovery forthcoming, some of which addresses some of our requests, some of which we don't. So I think it's a waste of our time to argue this extensive motion and memorandum of law. And I was going to explain why we filed such a detailed memorandum of law, but I don't think I need to waste the court's time with that. So I think what we're suggesting is, at least what we're suggesting, is that we come back on December 2nd, having had a chance to review what is coming, and then
Narrow the motion as to what you might still need. All right, I'm sure that's fine. If you determine that some of what you're requesting is Rule 17, do you anticipate being able to file them that day or not? I'm not telling you have to, I'm just.
well, I can tell the court that we're
You know, Bev would prefer that, though.
certainly looking at our request to see if they require Rule 17. And I'll just very briefly say that in our memorandum, when we address internal affairs, we are suggesting that right now, under the present facts and circumstances, that we argue in the memorandum that a Rule 17, even for internal affairs, isn't necessary given where we are today. And the court may certainly disagree, and we said in our memorandum, if the court orders us to follow Wayness, we will. But if we know that a Rule 17 would be required, I would anticipate we bring it with us.
And it's not necessarily regarding the internal affairs,
Right.
but other things you were looking
Exactly.
for, I thought were probably a little bit more obvious, Rule 17.
Okay.
So that's what I mean, not those. I understand litigating whether the IAD information is Rule 17 or Rule 14. I can see that maybe we will have to have that discussion, but the others that I think maybe after you look at what you have, you might think is Rule 17.
Yeah.
So on those, do you anticipate you might be able to file them by then, or it's too early to tell?
I think it's too early to tell.
Okay, how about if you can, you will?
That's absolutely right.
Okay,
Gosh, she talks to his defense attorney a lot like David Yannetti when they were trying to figure out dates for the potential retrial, which may or may not happen. I mean, who the heck knows what's going to reveal itself over the next couple of weeks, folks. But I mean, my God, somebody get that woman a frickin' White Claw.
all right, does that make sense, Mr. Connor?
Perfect sense, Your Honor.
12-2 works for me, Jimmy, does it work for you?
It does. It does.
Okay, do you want Mr. Walsh brought in that day?
I think we should issue a Hague, and then Mr. Walsh and all of us will talk and see if he needs to be brought in. But
Okay.
if we're going to have a hearing, yes, I do.
Sure, so we'll bring you back, Mr. Walsh, but if you don't want to come, let us know, and I think that.
And just finally, and I don't want to interrupt another Commonwealth, but the Commonwealth has filed a motion for protective order
Yes.
for some of this stuff. Right now, the status of that, we don't object to the protective order. Our understanding is that we can share the information with Mr. Walsh, but we're not going to give him hard copies of everything just yet. And we don't object to the redactions that appear today. We just want to review what we have, and then we'll come back. That's our understanding of the protective order.
That's our joint understanding. Your Honor.
Okay, that's what I would order anyway
Yes.
at this point, so, all right, so I'll allow the Commonwealth's motion for protective order. All right, we'll see you December 1st,
December 2nd.
December 2nd.
December 1st
All
is
right.
Sunday.
So Jimmy, you can take all my notes off of the papers, please, if you would. All right, thank you all.
Thank you, Your Honor.
Jimmy, I need you, buddy. Take these dang notes off my book. She sounds like she needs a nap. I don't know about you guys, but she sounds like she could use a nap. So in a filing last month, the Norfolk DA said they were provided with data from Proctor's work cell phone in August, as well as content from his work cloud account in September. However, despite heightened public interest in the case, they say the release of the information as discovery in the Reed case could jeopardize open investigation, compromise the privacy and safety of civilians, and thus be contrary of the interests of justice. So, in other words, that's why they filed for that protective order, because they don't want people like you and me to be reading this stuff. So, we actually covered some of the Proctor news and updates in regards to all of this hot mess express that he's now put himself, not only him in, but pretty much compromise any other investigation that is tied to the Proctor name. So as more updates unfold with not only this case, but other cases involving him, we will keep you updated here on Alexasrewm. Now, thankfully, the Canton police are not involved in this investigation. I don't know how reliable the Cohasset Police Department is. If anybody in the audience is watching who knows about the Cohasset Police or has any insight they can share, please let me know. So, Cohasset resident Brian Walshe, who is accused of unaliving his wife Anna, following an intensive investigation by the Cohasset Police Department and the Massachusetts State Police on January 5th after Anna had been reported missing. So, apparently, she disappeared in the early morning hours of January 2nd. So 3 days later, it took 3 days for her to be reported missing. Now, I don't know if he reported her missing. I'm assuming he did, probably to cover up his tracks, if in fact he is indeed guilty. And remember, innocent until proven guilty, but still, in this case, the evidence does seem overwhelming, but the MSP. So who knows? Cohasset police established that she never flew to Washington, D.C. and began the search for Anna. Walsh claimed that his wife had been called to Washington, D.C., where she worked due to an emergency. So Brian Walsh is saying, No, she works in DC. She flew there. I think she was like in real estate or something like that, right? So, according to this New York Post article from last January, Anna Walsh had a $3 million property portfolio that apparently her husband Brian was eager to inherit, according to some of these Google searches, which I guess the MSP was part of extracting. So he pleaded not guilty. And then a Norfolk County grand jury seated at Dedham issued 3 indictments against Walsh, who was 48 at the time, on March 30th for the unaliving of his wife, misleading a police investigation, obstruction of justice, and for improper conveyance of a human body. A conviction of M1 carries a mandatory sentence of life in prison without the possibility of parole. ADA Gregory Connor, so not Lally, but a different ADA, read from a lengthy statement that detailed the alleged motive in the case. What local media is referring to as a mountain of evidence. So this is going to be a huge issue for the Commonwealth's case because of Trooper Proctor's lack of credibility. And as we know, he is not going to testify in this case, which is wild because he's the lead investigator. So that's what's scary is like if he did do a proper job conducting this investigation, and what we know now with the internal affairs investigation that happened with Kevin Albert and his buddy Chip, it doesn't really look that good. Even if, in fact, this guy is guilty as sin, it does not look good, and it raises a lot of reasonable doubt as to the credibility of the investigation. From cell phone and iPad records and surveillance cameras. Oh, so you know how to find surveillance footage. That's good to know. At various locations he visited following Anna's disappearance, and also from internet searches ranging from how long it takes for a person to be declared dead. Wow, that sounds eerily similar to Jen McCabe's House Long to Die in Cold Google search, and how long someone must be missing in order to collect, how to remove blood stains, how to take out a SIM card. It's too bad he's not friends with Brian Higgins, right? Dispose of it on a military base. Nobody will find it. And a search of a luxury watches website, in addition to evidence found in a dumpster in Swampscott. This included a short black coat, black Prada purse, Gucci necklace, hunter boots, and other items similar to ones Anna wore, and used along with Anna's vaccination card and rugs consistent with those the Walshes had in their Chief Justice Cushing Highway home. DNA testing identified Brian and Anna Walsh as contributing DNA to many of the items that were found. A small bone fragment was also discovered that is being processed for DNA. In addition to video footage shows Walsh purchasing a Tynex suit, saws, trash bags, cleaning fluids, 5-gallon buckets, disposable rags, 24 pounds of baking soda, scented candles, rugs, and other items. The only thing missing is a bottle of wine, right? With the scented candles. According to the prosecution, the babysitter who took care of the Walsh's 3 boys in the days following Anna's disappearance later noticed that the downstairs rugs and a trash can had been replaced. Blood was also discovered in Brian Walsh's Volvo SUV. I wanted to say SVU. Volvo SUV in a number of areas, including the rear trunk. Other evidence shared by the prosecution includes that the door to the basement where red-brown stains were discovered had been padlocked. I mean, not for nothing, like, this seems like an overwhelming amount of evidence. This actually does. Whereas, like, comparatively, when you hear people talk about the Karen Reed case, there's an overwhelming amount of evidence. This is what overwhelming amounts of evidence looks like. But again, a lot of this is going to be problematic for the Commonwealth in trying this case, especially because they're not going to be calling who would have been their star witness, the lead investigator. The prosecution also revealed that with Brian Walsh's knowledge, his mother hired a private investigator in Washington, D.C., because he suspected his wife was having an affair, but that no evidence was found to substantiate that claim. Prosecution also stated that Walsh routinely visited the Instagram page of one of Anna's male friends from Washington, D.C. during this time. So during this arraignment, which again was, when was this published? April 27th, 2023. It was also revealed that Anna Walsh had taken out more than $2.7 million in life insurance on herself, with her husband as the sole beneficiary. After the evidence was laid out, Walsh's attorney, Tracy Minor, so somebody different than Larry Tipton, I don't think she was on his team for this, unless she was just his attorney for this portion of the case, maintained his innocence, and that while it's easy to disappear when you are an adult and single, it's not when you have 3 young children. There's no risk of flight here. Minor asked that bail be set, which was denied. In defending Walsh, Minor countered that no body has been found, that there is no indication of how Anna died. So again, this is a lot like another case I'm actually covering in the members only chat. So in the members only group. So if you want to become a member, definitely check it out. So this case is actually really similar to another case I'm covering inside the members only group. So if you want to become a member and you want to check that out, definitely recommend you do so. Mamta Kaffelbot is the missing nurse and mother of a 1-year-old from Virginia, and her husband was also charged with very similar charges, except in that case, he was only charged with concealing a body. And I'm sure a lot of that has to do with some of the laws in place, but there was also a lot of evidence that was recently collected. He is going to be actually going to trial in December, so we'll see what happens there, and we'll be definitely covering that. But her body was also not located. She's assumed dead, but she is still technically a missing person because she has never been found. So again, if you want to check out my coverage on that, feel free to become a member and do so. Under Massachusetts law, a person who is not presumed dead until they've been missing for 7 years or more, no indication of if or how she died, no motive or murder, or unaliving weapon, and that when Brian Walsh's mother told him she was hiring a private investigator, he said she was crazy and that Anna was a good person. Minor also said that there was no evidence of an affair before Anna went missing and that Walsh had no idea his wife was having an affair. She also said there were no signs of trouble between the couple when they entertained a friend on New Year's Eve. It was a celebratory dinner with each signing the side of a champagne bottle, saying that 2023 would be the best year ever and that only good things were going to happen in 2023. There was no indication of any discord, no feelings of anything but happiness between the couple. Their friend left at 1:30 a.m., and that was the last time she was seen by an adult. Because remember, she has 3 boys. Now, I don't know how old her children are, but I'm assuming they're probably young enough, but they might become witnesses in this case, especially if they were one of the last ones to see their mother, if they are old enough to potentially testify. And what a terrible thing, right? But this is crazy. It's like one day essentially into the new year, and she's taking a trip to DC. Like, that doesn't, I don't know, that doesn't really track in my mind. I mean, and there's no evidence. I mean, but again, what can we really trust when it comes to the MSP? And this is what's so incredibly frustrating. Minor said that Brian Walsh is a primary caregiver for his 3 kids. Besides the internet searches outlined above, according to Minor, other searches during that same time frame included where to go for a family vacation in 2023. Minor also maintained that of 8 separate swabs taken from the basement, the one that was tested came back negative from the lab. I'm not sure of the other 7, she stated. The spots found in the basement looked like rust. It's an old basement and an old house. So again, where it comes to chain of custody, that is also going to come into question. How evidence was collected, how it was transported. These are all big things that that his defense team can raise. Even if he is guilty AF, it's going to look really bad in the eyes of the jury, especially, in my opinion. Minor also said that the Tyvek suit also tested for another person's DNA and that many of the supplies Walshe purchased earlier remained untouched in the basement. Regarding the life insurance policies, Minor said there is no evidence that Brian Walshe was in need of money and that his mother, who she said is wealthy, has given tens of thousands of dollars to Anna and Brian. Well, I don't think Anna needed money because she had a $2.7 million life insurance policy. And from that New York Post article, she had over $3 million in real estate in her real estate portfolio. So I don't really think she was hurting too much for money. But it sounds like he was, if he's trying to pawn off fake Andy Warhol art, right? Her client has remained cooperative throughout the investigation, she said. Cohasset Police Chief William Quigley. Why do I feel like I've heard that name before? Was unable to comment due to the DA's embargo on all comments.
Detectives from the Cohasset Police Department and the Massachusetts State Police detectives assigned to the Norfolk District Attorney's Office have been involved in an intensive investigation into the fate of Anna Walshe, a 39-year-old Cohasset mother of three, since she was first reported.
This is the exact place that he made that video, as Melanie Little calls it, the hostage video. Like, it's the same. I wonder if he shot it in the same day. When was this? This was a year ago. January 17th. So the hostage video, but this looks like the same exact like outfit look. Like, did he reuse the same set? He's like, guys, I have the set already in place. I got the right camera angle. I got the right suit, the right tie. Like, hold on. I gotta look this up. Okay, so it's not the same tie, but it's definitely the same suit. This time he's got glasses. It's the same location, just a slightly different camera angle. Well done, Mr. Meatball. Well done. But this was like 6 months prior to him making that statement, no?
Missing on January 4th. Early in this investigation, the police developed probable cause to believe that her husband, Brian Walshe, age 47, had misled police investigators on material matters important to the search for Anna Walshe. He has pled not guilty to those charges and is currently being held at the Norfolk County House of Correction. The continued investigation has now allowed police to obtain an arrest warrant charging Brian Walshe with the murder of his wife. Mr. Walshe will be transported to the Quincy District Court for arraignment on the charge of murder. Additional details of the investigation and the evidence in support of those charges are likely to be presented at arraignment, but will not be disclosed at this time. This marks the second allegation of domestic violence homicide in Norfolk County in less than a month. Our thoughts are very much with the family these crimes have left behind.
He's really good at reading. He's like so good at reading, I couldn't even tell. Could you tell, guys? So let's go. He is the worst public speaker I think I've ever seen. You gave more passion in your statement about Colin Albert not being in the house, also being a witness in the Karen Reed case, even though he wasn't in the house. You gave more passion about that than this case right here. I mean, bravo, my good sir. So let's get into this motion for discovery. So this was, again, filed on September 24th. The outcomes counsel for the defendant, Brian Walshe, and respectfully requests that the Commonwealth inquire and disclose the following information. And 2, if such information contains what is considered confidential or protected information, that it be produced pursuant to a protective order, which again they went over in today's hearing about how they are going to redact a lot of the information that might compromise the integrity of those cases. Although I think integrity and chip Proctor don't really go in the same sentence together. 3, if after proper inquiry to acknowledge such inquiry for any category listed below where it was determined that no such information existed. So 1, a complete copy of all data referred to in the Commonwealth's notice dated September 6, 2024, described as an extraction of Trooper Proctor's work cell phone. I wonder who did the extraction, too, of Trooper Proctor's, or who is going to, rather, and Trooper Proctor's work cloud account. A complete copy of an estimated 3,074 pages of materials and documents provided by the Department of Justice to the Norfolk County District Attorney's Office regarding its investigation into the death of Officer John O'Keefe. Complete copy of all correspondence between the DOJ and the Norfolk County District Attorney's Office regarding its investigation into the death of Officer John O'Keefe. I like how they're referring to John O'Keefe as Officer John O'Keefe. I like that they are respecting that. A complete copy of any documents, correspondence received from the U.S. Attorney Josh Levy has entered the building, folks, or any other federal agency concerning the Norfolk County District Attorney's Office investigation into the death of Sandra Birchmore. Complete copy of any documents and materials regarding the policy, protocols, or agreements, including any memorandum of understanding between the Massachusetts State Police and the Norfolk County District Attorney's Office related to the assignment of state police to that office. Any and all notes, reports, memoranda, or other documents related to the investigation of State Trooper Pooper Chip Proctor and his conduct in investigating the death of Officer John O'Keefe and the whereabouts of Anna Walshe, including but not limited to the following: notes, records, memoranda, and any other documents concerning Proctor's job performance. Notes, records, memoranda, or any other documents concerning disciplinary actions, formal or informal, of Proctor. Notes, records, memoranda, or other documents concerning complaints or any similar communication from any party concerning the conduct of Proctor. And believe me, there's plenty of complaints here. Notes, records, memoranda, or other documents concerning the supervision of Proctor. So his boss, Sergeant Bukwacki. Tully. The Commonwealth or any of its agents. These boys are going to get busy. Notes, record, memoranda, or other documents containing information of any person, including state police, local police, investigator, or forensic consultant supervised by or required to report directly to Proctor. So I am curious who was in charge of extracting those Google searches, because I don't know if it's been reported yet if it was Garino or not. Any and all internal affairs records, memoranda, or other documents regarding Proctor, any and all policies, protocols, directives, or memorandum of understanding regarding the supervision of state police, signed to Norfolk County District Attorney's Office. Any and all notes of all state police and any member of the Cohasset Police Department involved in the investigation of this matter concerning the investigation of this matter. Any and all reports, memoranda, or other documents containing information concerning the investigation of this matter that have not thus far been provided as of the filing of this motion. Any and all notes, reports, memoranda, other documents concerning interviews or conversations with prospective grand jury witnesses, regardless of whether the witness was in fact called to testify before the grand jury in this matter. A lot of this is repetitive, so I'm just kind of gonna breeze by it. From any victim advocate concerning any information concerning the investigation or disappearance of Anna Walshe. containing any reference to leads arising in the investigation of this matter of persons who are or were considered as targets, suspects, or third-party culprits, regardless of the outcome of any investigation, regardless of whether such persons were ever investigated. Concerning communications of the state police, because those boys like to group chat each other. Send photos of people's attorneys, the defendants' attorneys, search for nude photos of female defendants, female suspects. Of the Cohasset Police Department, any person at a different police department, federal law enforcement, and any agent of the Commonwealth and the district attorney for Norfolk County concerning the investigation of this case. Any and all cellular telephone records in the possession of the Commonwealth or its agents of any state police and any member of the Cohasset Police Department involved in the investigation. Any and all text messages in the possession of the Commonwealth or its agents of any state police and any member of the Cohasset Police Department involved in the investigation of this matter. Does he have a buddy like Kevin Albert in the Cohasset Police Department? I wonder. Working on a cold case while cracking open a cold one. Any and all social media records in the possession of the Commonwealth or its agents of any state police and any member of the Cohasset Police Department involved in the investigation. Finally, the defendant requests that if it is determined that no information in any of the above categories was deleted, destroyed, or lost, the Commonwealth inform counsel of that conclusion, including the time, place, manner, and means and the circumstances of any deletion, destruction, or loss of the information. Yeah, like ring camera footage, surveillance camera footage, inverted Sally Port videos, right? Because this also happened in the winter. As grounds, therefore, the defendant asserts that the request for inquiry and disclosure as requested is necessary for the adequate preparation of the trial of this matter for the reasons set forth in the attached memorandum of law and fact. In summary, here these requests are based on the revelations of bias and a lack of proper supervision of the state police. So even though Sergeant Bukwacki only gets 5 unpaid vacation days, right? Assigned to the Norfolk District Attorney's Office, and the biased statements of Trooper Michael Proctor, the DOJ investigation into the handling of the death investigation of Officer John O'Keefe, the production of 3,072 pages of documents produced to certain parties regarding that death investigation, the fact that portions of correspondence between the DOJ and the DA's office have been released, that the Commonwealth has received digital data regarding Chip Proctor, and the troubling emerging facts and circumstances regarding the DA's office investigation into the death of Sandra Birchmore. The failure to produce the specific information requested herein results in a violation of the defendant's rights established by the 6th and 14th Amendments to the Federal Constitution, Article 12 of the Massachusetts Declaration of Rights, establishing the defendant's rights to effective assistance of counsel, due process, and a fair trial, Mass. R. Crim. The rules, so this was the Rule 14 that I guess they were talking about. The rules of professional conduct concerning the duties and obligation of the prosecutor and the common law. Larry Tipton. Makes me think of The Sweet Life of Zach and Cody. So this is their affidavit in support of the defendant's motion for production of information concerning the district attorney and law enforcement. I, Larry Tipton, not to be confused with London Tipton, A Sweet Life in Zach and Cody, state the following to be true to the best of my knowledge and belief. I along with, attorney Kelly Porges. So I guess this is a different attorney than from that article from last year. Represents Mr. Brian Walsh in this matter, charging him with M1. Mr. Walsh's motion does not allege the Norfolk District Attorney's Office of any wrongdoing. I mean, that's an understatement. Don't know if I agree with you, buddy, there, but I wouldn't say of any wrongdoing, period, but maybe in regards to this specific investigation in these charges. The motion addresses what has been revealed as serious questions about the conduct, decisions, and bias in its investigations, the biased and inadequate supervision of the state police assigned to the office and other police departments reporting to the office in its investigation is in an effort to require production of any exculpatory evidence that raises questions about the investigation of Mr. Walsh. So, they're not blaming the DA's office, they are blaming the state police. The request for the information set forth in the motion is based, at least in part, of the factual record now firmly established that the relationship between the state police and the DA is flawed, problematic, and results in a lack of integrity, bias in investigative decisions, conclusions, and opinions. It is clear that, based on the evolving factual record regarding Chip Proctor, that there exists a lack of supervision, that biased decisions, conclusions, and opinions are allowed to flourish, and that these biases infect the myriad of decisions made during the investigation and prosecutions handled by these law enforcement personnel and the DA. His observation is not the single opinion of defense counsel, but shared by others. The DOJ initiated an investigation of the DA and its mishandling of the prosecution in the matter of Commonwealth versus Reed. Yep. There appears to be either a similar investigation or, at the very least, concerns for the lack of sufficient investigation into the matter involving the death of Sandra Birchmore. Yep. The understatement of the century. Furthermore, there is factual record evidence that Proctor was not properly supervised by his state police supervisor and was permitted to espouse biased and prejudicial comments regarding at least the defendant in the aforementioned case, and there is nothing to support a belief that other law enforcement personnel purportedly supervised by the state police. So we read that already. My experience as defense counsel indicates that Proctor's supervisor, Detective Lieutenant Sully, has either knowingly or mistakenly represented facts in the recent case of Commonwealth versus Lopez. Misrepresentation that were litigated by way of extensive pleadings, and in those instances, Tully had to admit his mistakes, made in reports and sworn testimony to the grand jury and at the first trial of the matter, but only after confronted with defense pleadings demanding the truth. These instances include, but are not limited to, the following: misrepresenting to the grand jury that certain critical messages were in fact read by the defendant that, if not corrected, were to be used to establish the defendant's mental state and motive. Misrepresenting GPS location data, and I wonder who was in charge of, again, is extracting that GPS data, because if it's Garino, I mean, it's not looking too good for our boy over there. That, if corrected, would have been used to suggest that the defendant's whereabouts at critical times immediately preceding the incident, and notes ordered produced by way of motion that revealed that Tully's investigation reports submitted in the case did not include important details of the observations of the defendant's mental state by a critical witness at critical times immediately preceding the incident. Another example is a report submitted by other state police investigators in that same case that were intended to support an argument that the defendant mocked the police on social media, were eventually shown to be unreliable, and upon motion by the defendant were eventually not used by the Commonwealth. I don't know really anything too much about that case. I know that Lopez has been recently convicted. For those of you who did follow that case, definitely let me know. At least one legal scholar has been quoted in the Boston Globe regarding the emerging facts of the Birchmore investigation, the Chip Proctor matter, that the entire infrastructure is built so that the prosecutors are able to protect officers who were their star witnesses. It is clear that in the Proctor debacle, and based on experience of defense counsel, the biases and detrimental impact of such biases and flawed relationships appeared historically to only be forthcoming when defense counsel, as was the case in Commonwealth versus Reed and in Commonwealth versus Lopez, bring a court's attention to what it is believed to be exculpatory evidence of the professional negligence that otherwise would have remained hidden from view. They attached some case law. And yeah, they want everything. I'm sorry, I'm not gonna read through everything word for word just because some of it is repetitive and they kind of already summed it up earlier. These requests are granted in the belief that only due due diligence and a review of the materials by experienced defense counsel well versed in the relevant allegations of this case and information derived from its ongoing investigation can determine whether inherent bias, professional negligence, or casual disregard for justice has permeated the investigation of Mr. Walsh. I mean, these are all very valid points, which is scary because, I mean, if this evidence was bagged and tagged correctly and all roads are pointing to Walsh, which it does seem, how can that really be trusted? When everything else has been fudged kind of in the way that into a narrative that they want in regards to specifically the Karen Reed case. What's more, this is my favorite part, right? Right, there we go. What's more, Proctor, as case officer of the investigation, because remember in the Karen Reed case, guys, he said I wasn't the lead investigator. I mean, I wasn't the only one working on it. I was the case officer. That's what he called himself. I love that they called that out. Mr. Walsh, as well as other state police assigned to the DA's office, were in charge of and intricately involved in the investigation of Mr. Walsh, resulting in the indictment charging him with what? In this case, until he was suspended, Proctor was considered the lead or primary investigator. Yep. Same with Karen Reed. Was involved in interviewing critical witnesses. I wonder if he recorded those interviews. Was presented, and I wonder if he separated witnesses as well too when he was conducting those interviews. Was present for a majority of the grand jury presentations, reviewed other investigator reports and forensic reports, presumably interviewed and prepared grand jury witnesses, and supervised other agents of the Commonwealth, helped in the drafting of the reports, determined what leads to follow and to not follow, and made a decision or was instrumental in making a decision to target Mr. Walsh, and in summary, shaped the scope of the investigation leading to the indictment. Importantly, the investigation of Mr. Walsh was being conducted at or around the same time Proctor, his supervisors, and other agents of the Commonwealth were investigating the aforementioned Reed case and making biased and unprofessional remarks and decisions. And that is a really good argument, in my opinion. It's like, yeah, this was all going on at the same time. And if they zeroed in on Karen Reed in less than 24 hours, I think it was like 16 hours, right? Then how can you claim that this was done with the utmost integrity? And now he's been suspended without pay, dummied down to desk duty. So, and he won't be testifying in this case. Like, that does not look good. It doesn't. Which they state here. It's also now clear that the Commonwealth has not also determined not to call him as a witness. This decision speaks volumes about the impact Proctor's conduct has had on his investigation and lends substantial support for production of the information sought in this motion. Now, I have to say, folks, I don't know, wouldn't it be a conflict of interest for Beverly Cajonas to be the judge presiding over this decision because she heard Proctor's testimony in the Reed trial. She was the presiding judge in that trial. And if she's going to sit as that judge for the next trial, regardless of whether she is or she isn't, wouldn't it be a conflict of interest? I don't know. Law friends, tell me. I just see like that as not being good. And continuing to show the bias. I don't know if they filed a motion for her to recuse herself. A suggestion that someone independent of the DA's office is qualified to review documents in this matter under these attendant circumstances ignores the SJC's reasoning, logic, and decision to change the framework for evaluating statutorial privilege records in Commonwealth versus Dwyer, as discussed in the accompanying memorandum, doing away with in-camera review, establishing a review process whereby defense counsel with protections in place to ensure there is no disclosure of privileged information. The bias and resulting damage may be intentional. It appears to be in many instances. In 1, the Proctor matter. 2, failing to include relevant and exculpatory information in final reports as described above. And 3, in the DA's office presumably being unaware of the Proctor's negligence. It is not an overstatement to simply state that defense counsel, knowing the allegations, relevant facts, circumstances, possible defenses, and information not in the possession of the Commonwealth based on the defense investigation, is in a better position to determine what is potentially exculpatory evidence buried in the information requested. Importantly, the requested documents are not privileged by statute, even where there is heightened concern that sensitive information not be revealed, because that's why they want the protective orders. They don't want to, quote, compromise other investigations that are ongoing. Protective orders have long been used by the courts to guard against such disclosure. The bias and resulting damage may be intentional. It appears to be in many instances in 1, the Proctor matter, 2, in failing to include relevant and exculpatory information in final reports as described above, and 3, in the DA's office presumably being unaware of Proctor's negligence and bias, and when made aware of the same, sought to diminish it and its impact on the prosecution in the Reed matter. Apparently, that has now changed over time, with Proctor being suspended and the Commonwealth belatedly determining they will not call him as a future witness. And it is critical to consider implicit bias and the resulting need for these requests in this case. I mean, I guess in that way, the defense for Brian Walshe would want Bev to be the sitting judge on this, because she literally witnessed Proctor saying the "see you next Tuesday" word live in a court and asked him to say it. And while he was reading those other disgusting, disturbing text messages about Karen Reed. So, I mean, I don't know. It could go either way. Or she might be like, yeah, I don't want to deal with this, and this is going to go to somebody else. I don't know. The SJC has approved and recommended a preliminary and final instruction on implicit bias This court should not ignore the implications of implicit bias as it pertains to law enforcement decisions made in the investigation of Mr. Walsh and other cases. For example, jurors are instructed in part to not rely on personal and unsupported assumptions you may have and to do your best to resolve this case based upon the evidence and law without sympathy, bias, or prejudice to the best of your ability as human beings. Should be applied to the DA's office and its agents. Apparently, it does not in all occasions. There is literature to support the effects of implicit bias on professionals such as police officers and prosecutors. In conclusion, the requested discovery should be ordered, produced, based in part or in the whole on the established fact of Proctor's conduct, leading to his suspension, and now the Commonwealth's decision to not call him as a witness and the other reasons stated in the defendant's motion. I mean, again, I don't know too much about the other two cases that uh, he was referencing in this, but I definitely think that they anything that has really revealed itself, right? In the Karen Reed case is going to make for a really strong argument. I just don't know if Bev is going to be the right person for that call. And the other reasons stated in the defendant's motion, including but not limited to the association between the DA's office and Proctor and the state police, wherein state police officers are specifically assigned to and provide investigation services to the DA's office in the investigation of alleged crimes. The investigation of the DA's office by the Department of Justice and the Boston office of the U.S. Attorney and the emerging information regarding the flawed investigation of the death of Sandra Birchmore. And I think the Sandra Birchmore case is also a very legitimate argument as well, too. So, but I think the strongest is probably going to be right now, just because Proctor, I mean, Proctor was kind of part of the Sandra Birchmore investigation, but there were other elements, I mean, as we know, Nick Carino played a heavy role in that. So if he did play a heavy role in the extractions of Brian Walsh's Google searches and cell phone data and GPS locations and all of that, that is going to be a huge problem as well too. So, but in regards to specifically Chip Proctor, I don't think he had a huge level of involvement, what if any, at all in the Sandra Birchmore case. So I'm not going to go through the memorandum just because we already went through all of what exactly they're seeking. I will attach this link below so you can. I want to get to the Commonwealth's response, though. That literally showed up a few hours before. So, Commonwealth to defendants motion for discovery of documents related to the district attorney and law enforcement. Now comes the Commonwealth. Can I zoom in on this? I can zoom in. Why didn't I zoom in before, guys? Now comes the Commonwealth in response to the defendants. Let's just look at the date on this. There is no date at the top. Request for material pursuant to Massachusetts Rule of Criminal Procedure 14. The Commonwealth addresses each request as follows. A complete copy of all data referred to in the Commonwealth's notice dated September 6, 2024, described as an extraction of Trooper Chip Proctor's work cell and his work cloud account. So this is their response. The Commonwealth objects. We object as beyond the scope of Mass Art Crim P14. Commonwealth alerted the court and the defendant that there is privileged information. So again, on his work phone, Commonwealth has sought the assistance of an independent examiner to review the contents of the phone and cloud information in the meantime. But again, it's like, who is this independent examiner? Like, who is going to be the person in charge of doing that? Can they be trusted? Is this a third party, non-biased person? Probably not, because we know how they operate. In the meantime, the Commonwealth is reviewing the extraction reports for all exculpatory evidence that pertains to this investigation, and they better hand it over, otherwise that's a Brady violation, including any allegations of misconduct that bear upon truthfulness or could be read as suggesting bias, as well as any material that would question one's credibility or ability to be impartial. I mean, like, but you can't. I mean, you looking through the extraction reports, you can't really decide what's exculpatory and what isn't. That's not really up for you to decide. That's up for the defense counsel to decide what they want to use or not use, right? To build their case. They have a right to access all of that information, which was a big issue in the Alec Baldwin case, and essentially why Carrie Morrissey totally botched that case and those charges were dropped. And that case was ultimately dropped by Judge Summer is because and Carrie Morrissey takes the stand because she decided, oh, well, I don't think this evidence is important to share with you. And Baldwin's team came in with a clutch argument. And I don't know if they quoted this in their memorandum as part of that case law. Maybe they did. And if you guys want me to go through the memorandum, I will, but not in today's video specifically. I just wanted to go through what exactly they were looking for and all, and the updates in regards to today's hearing. But that's why Carrie Morrissey took the stand. She was in Brady violation. So, a complete copy of an estimated 3,074 pages of materials and documents provided by the DOJ to the Norfolk County DA's office regarding its investigation to the death of Officer Don O'Keefe. They object. The majority of material is subject to a judicially signed federal court order that restricts the recipients from disclosing or disseminating these materials and documents, and such the materials and documents are not within the control of the Norfolk DA's office. So that's a whole bunch of word salad. Essentially what I'm gathering is that they're saying it's not up to us to decide whether or not you can get that materials because it's in the U.S. Attorney's hands now. Commonwealth has recently received outside that court order certain text messages referenced at trial and will produce those text messages to defense counsel subject to our request in the Norfolk Superior Court for a protective order. Request for other information should be made to the U.S. Attorney's Office. Yeah, so they're saying we don't have access to that, but the feds do, which is not a good look. It's just not. Complete copy of all correspondence between the DOJ and Norfolk County regarding the investigation into the death of Officer John O'Keefe. Commonwealth objects as beyond the scope of Massacre. Oh, I missed a footnote, I think. Where did I miss this? Oh, this was from the last one. Sorry, guys. Notice and preservation of evidence upon receipt of information that any item described in subparagraphs yada 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 exists except that is not within the possession, custody, or control of the prosecution, persons under its direction and control, or persons who have participated in investigating or evaluating the case and either regularly report to the prosecutor's office or have done so in the case. The prosecution shall notify the defendant of the existence of the items. Yeah, don't hold your breath on that. And all information known to the prosecutor concerning the item's location and the identity of any person possessing it. At any time, a party may move for an order to any individual, agency, or other entity in possession, custody, or control of items pertaining in the case, requiring that such items be preserved for a specific period of time. The court shall hear and rule upon the motion expeditiously. Court may modify or vacate such an order, showing that the preservation of particular evidence with significant hardship on condition that the probative value of said evidence is preserved by a specified alternative means. So yeah, they're like, shut up, contact the feds. We don't have it, allegedly. As there is not showing of relevance or materiality. Are you serious? This is all completely relevant. This is totally irrelevant. They want those letters before They want those Josh Levy letters, and I don't blame them. I would want those too. All other correspondence would be considered work product. Be subject to the investigatory exemption and or communication subject to the federal protective order. Any documents, correspondence in regards to the death of Sandra Birchmore, of course they object. Should counsel be seeking reports and videos related to the death of Sandra Birchmore that were previously made public, the Commonwealth will produce those emails. The public records law, pursuant to the public records law, correspondent with the U.S. Attorney's Office and or federal agency would be exempt under yada 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 investigatory exemption, as there is a pending federal prosecution. So they're saying because Matthew Farwell has been indicted, they don't have to cough up anything. I don't know how true that is. Complete copy of anything related to the assignment of state police to that office. There's no memorandum of understanding generated by the Norfolk District Attorney's Office or the Massachusetts State Police. In response to your request, the legal department for the Massachusetts State Police has provided Massachusetts State Police general investigation policies, which includes supervisor responsibilities. State Trooper and his conduct investigating this death of Officer John O'Keefe and the whereabouts of Anna Walsh, including but not limited to notes, records, memoranda, other documents, Proctor's job performance, disciplinary actions, formal or informal, of CHAP, concerning complaints or any similar communications from any party concerning the conduct of CHIP, concerning the supervision of Proctor by the state police. So Bukwacki and Tully, even though Bukwacki wasn't mentioned in this, so I don't know, but we know he is his supervisor. I just don't know if he was necessarily, if his supervisor for each case is like assigned to a different person. I don't know, or if it's the same supervisor. Local police, forensic consultant. Okay. So they're just kind of going through the different things that they requested. The Commonwealth will produce all law enforcement notes related to the disappearance and unaliving of Anna Walsh. Commonwealth had notified counsel of a pending internal affairs investigation and that Trooper Chip Proctor is, as of this date, suspended without pay. Yeah. So he's just suspended without pay. The Commonwealth is producing the Massachusetts State Police Office of Professional Integrity documents pertaining to Chip and, okay, there he is, and Sergeant Bukwacki, okay, that are currently within the custody and control of the Norfolk DA's office. Got some more case law there. The Commonwealth will also produce the official transcripts of Proctor's testimony. Commonwealth versus Karen Reed. That should be good. I can't wait for these oral arguments, man. These are going to be wild. It's wild. Mark your calendars, boys and gals. Other materials not within the possession, custody, or control of the NDAO would be in the custody of the MSP of Professional Integrity and subject to Mass Rule Crim rule. So I guess Rule 17 motion. Internal affairs records, memoranda, or other documents regarding Proctor. See response 6. So the same thing. They're going to include anything related to the unalivement of Anna Walsh and any other, or like, see, yeah, if there's anything we send you, then it's because it's under the custody of the professional integrity personnel. We'll continue to produce to the extent records come within its control and custody pursuant of Mass or Crim. More case law, other materials not within the possession, custody. Okay. So again, it's the same copy and pasted answer as before. Policies, protocols, directives, or memorandum of understanding, the supervision. So see response 5. So they're saying there is no memorandum of understanding that was generated by the Norfolk DA's office. I'm excited to also see too their response, his counsel's response to this, because they want the whole policies and procedures of everybody. Any and all notes of the state police and any member of the Cohasset Police Department involved in the investigation of this matter concerning the investigation of this matter. No objection to notes of statements of witnesses, but like, isn't there? So like, there's no recorded interviews? I'm confused. Commonwealth has previously provided all notes Sergeant Harrison Schmidt, see Notice of Discovery 2, Item 229. And the notes from personnel at MSP Crime Lab contained within the documents of Notice of Discovery 3. The Commonwealth recognizes its ongoing discovery obligations and will produce any remaining notes. The Commonwealth will inquire of all law enforcement witnesses as to the existence of notes. But what about recorded footage and transcripts? That's what I'm more curious about. Any and all notes, reports, memoranda, or other documents containing information concerning the investigation of this matter that have not thus far been provided as of the following of this motion. No objection. The Commonwealth would continue to provide notes of statements of witnesses and all materials entitled under Rule 14. Any and all notes, reports, memoranda, and other documents concerning interviews of grand jury witnesses, regardless of whether the witness was in fact called to testify before the grand jury in this matter. Okay. All right. All right. Any and all notes, reports, memoranda, or other documents from any victim advocate concerning any information concerning the investigation of this case or disappearance of Anna Walsh. Commonwealth objects. Victim witness advocate has no statements of witnesses. The notes concern contact with the family of the unaliving victim, Anna Walsh. Commonwealth recognizes its duty to inquire. So, okay. Well, I mean, but again, with what family members? And it is very possible that some of the family members could be called as witnesses. I don't know if they've released a witness list yet. I'm sure that they haven't. They haven't even set a trial date. So, I mean, but how can you determine like who's going to be called a witness or who's not going to be? Right? And I guess they're saying to witness of the crime, but still, again. So, any and all notes, reports, memoranda of other documents containing any reference to leads arising in the investigation of this matter or persons who are or were considered as targets, suspects, or third-party culprits, regardless of the outcome of any investigation and regardless of whether such persons were ever investigated. Commonwealth has previously provided all notes and reports containing the information regarding targets, suspects, or third parties known to the Commonwealth. To the extent that the defendant's request involves individuals associated with the defendant's own federal prosecution, Commonwealth does not possess the information or material, and a request should be made to the U.S. Attorney's Office. So I guess they're referring to his charges in regards to the fake Andy Warhol, which he was found guilty of. So I guess that's what they're referring to there. Reports, memoranda, or other documents concerning communications of the MSP, any member of the Cohasset Police Department, any person at a different police department. Because we know Chip loves to talk to his buddies who don't even live here. Buddies who may be also police officers, like Kevin Albert. The request is overly broad. The Commonwealth has provided all statements of witnesses under Rule 14. The Commonwealth objects to the request for work product which are not subject to Rule 14. I mean, I guess I get what they're saying here is like you're saying, well, just like any communications ever, like what specifically? But I mean, yeah, where Proctor is concerned, I would specifically say where Proctor's concerned, who he's communicated with in other neighboring police departments, right? Like I think the big things are like, yeah, the letters between Morrissey and Josh Levy, right? Anything regarding the Sandra Birchmore investigation, specifically with Canton Police failing to properly secure that crime scene and collect evidence. Everything to do with Karen Reed and that investigation, the bias in that investigation, the connection between Chip and the Alberts, all of that. His testimony, all of that. His communications to his buddies, right? Any and all cellular telephone records in the possession of the Commonwealth or its agents of any state police and any member of the Cohasset Police Department involved in the investigation of this matter. So they're saying again, it's broad, but I don't know. I mean, specifically, but I don't know. I'd be curious to hear their argument. I don't know if they're gonna win that one. Any state police and any member of the Cohasset Police Department involved in this investigation or matter in the possession of Commonwealth or its agents. So they say the same thing. Look at Rule 17. Any and all social media records in the possession of the Commonwealth or its agents of any state police and any member of the Cohasset Police Department involved in this investigation. I don't think they're gonna get that. I don't think that's as strong. But I mean, again, we did see, like, if they're specifically referring to the Instagram account of Joshua Heel, which we talked about in my last video or one of my last videos. Yeah, I mean, that directly involved. He's a witness in the Sandra Birchmore case, absolutely. And potentially one of her ABUSERs. He's never been charged, but all roads lead to his disgusting Instagram account where he was allegedly talking to minors. So, I mean, not saying that the two are connected, but I mean, yeah, I could definitely see them requesting or wanting to get access to the social media accounts. But I don't know. I mean, I would say definitely for Chip, his supervisors, anybody in that text thread, because who could have been potentially involved from the MSP in investigating this case, I definitely think is 100% fair and accurate. But I think you need to get specific and name those names, right? Finally, the defendant requests that if it is determined that no information in any of the above categories was deleted, destroyed, or lost, Commonwealth inform counsel of that conclusion, including the time, place, manner, and means, and the circumstances of any deletion, destruction, or loss of the information. I mean, I don't think that's overly broad. Like, there was a lot of stuff that was deleted or missed and tried to be explained and wasn't ever explained. Specifically in the Karen Reed case. And I am curious to read the memorandum and see how they're justifying and backing up those arguments and where they're citing the case law. But oh wow. So yeah, they object. I mean, maybe they're talking about the inverted Sallyport video, I would imagine. The missing 42 minutes of that footage, the Ring camera footage. the non-existent ring camera footage. So this was what was frickin' submitted hours before. This was 10 pages long. Hours before his hearing today. And they were supposed to go in and argue. Now, I don't know anything about this ADA, but it is coming out of Morrissey's supervision. So what say you? But we're going to keep you posted here on what goes on. And yeah, December 2nd, mark your calendars, boys and gals, because this is going to be quite the argument, I would say. I think they actually have a pretty strong argument, especially in regards to Proctor. It doesn't look good for the Commonwealth. It doesn't look good that they just responded. I think that Bev was annoyed. She probably needs a nap, a little cranky. Not excited to be in court in December, but I mean, we'll be there. So, what say you? I mean, do you think that the defense team for Brian Walsh has a solid argument? I've heard a little bit about it, so I know enough where at the time I was like, holy smokes, like this is a smoking gun. Like they have mountains of evidence. It has to be this guy. It has to be him. And not saying that my doubt has shifted in any way. I definitely believe that he is guilty. But that being said, I mean, he does deserve a fair trial. We're all entitled to have a fair trial. That is our constitutional rights to a fair trial. And he is presumed innocent until he is found guilty. But I mean, it's so scary. It's so scary that morons like Chip, you know what? Like, you could have done a really bang up job with this one guy, right? And we could have gotten justice for Anna Walsh, and hopefully we do. But at the same time, it's I'm so conflicted because it's like I want justice for Officer John O'Keefe. So if you want to stay up to date with all the latest going on in the Norfolk County DA's office, make sure you hit that subscribe button. Make sure you hit that notification bell so you don't miss the next Brian Walsh update for me. And make sure you hit that like button because that tells the YouTube algorithm that this is newsworthy news. So let's continue to make some noise for Anna. Anna deserves just as much justice as Sandra Birchmore, as Enrique Delgado Garcia, as Officer John O'Keefe. Let's continue to get the story out, continue to put pressure on the DA's office to hopefully do the right thing, and hopefully the right thing was done in this specific case. I mean, I'm trying to keep an open mind to it, but I mean, I don't know. It's really hard to put your faith into somebody who has totally just blown your trust. I mean, it really is, and I'm not holding a lot of high hopes, and I don't know what this means for justice for Anna Walsh and her 3 young boys. So that being said, I will see you in the next video.